the panel member need, and yeah, every other politics of oral examinations. So for me, I think with this session, I'll just do questions from you, not from me, because Solanka may not be available today, and my other colleagues been held up for the past 2 days. So just got on like 2 hours ago. Okay. Fine. Any questions that perhaps you need addressed? Yes, please go on. Where I think that's it. Just go on. Just...
Okay, hi. Thank you so much for taking the time. I just wanted to ask whether you can explain as well as you can or however you can about the concept of protests, objections, citations, and caveats under the law of succession. Like how do they work? What's the distinction between them? Yes.
Perhaps I should just collect a number of questions, and then if I were to address them, I would do so collectively. But your question is noted. Mm-hmm. Any other person, perhaps with a pressing question and concern that needs to be addressed, so that if I were to begin, I would just do so, one after the other to avoid wasting too much time. What exactly, threw you off balance from the questions you came across? What exactly do you feel, it's kind of eating you up inside and you want it to be addressed? With regards to the questions, right now you've come across a number of questions, a myriad of questions. So it's you who knows exactly, as aware of the shoe, you know exactly why it hurts. So Molly is. Mm-hmm. You're free. Please go on. Anyone else? Is it Lorraine Mwangulu? Your hand is up.
Yeah, I just wanted to seek clarification on the difference between a regular and irregular judgment.
Okay. Anyone else? Is it Were? Immaculate? Yes, please.
Yes, yes. So there's a person who was asked about documents accompanying a plaint, and then the follow-up question was instances where you don't file a witness statement. So I just wanted to find out what will be the answer for that. Yeah. Then apart from that, I don't know if you can also explain the concept of representative suits in detail and also interpleader.
Oh, okay. Perhaps if I was just to begin by protest. You see, protest. Sorry, I have a cold. You see, protest actually related, to objections. Okay, so they are more or less like a CMA strains. They are inseparable. So it's hard to distinguish one from the other. So when you look at Rule 40, Rule 40, I think sub Rule 6 of the probate and administration rules, yeah, basically highlights, protest in its detailed sense. I don't know, because if I were to brush through all those all that procedure, actually from Rule 40, yeah, Rule 40 itself of the P&A rules, you look at how protest relates to objections, and especially on issues to do with caveats. I think in conversing, caveat to probate and administration is what caution is to conversing. I hope you're noting the difference. But besides, I mean, both of them have an underlying factor, which is basically a warning. So while caution is in I think section 71 to 75 of the LRA, and regulation 80 of the land registration general regulations of 2017, regulation 80 of the land registration general regulations of 2017 talks about caution and the procedure for lodging a caution. Who can remove? Is caution, removed? Can it be removed? If so, by what form of the, LRA? Yeah, so such things. So now back to protest in probate. You see, protest follows, lodging of a caveat. So you actually cannot protest if you haven't, placed a caveat over the particular estate that you seek to protect. So secondly, you only protest if you are in the succession matrix. This is to mean that, you are either listed as a beneficiary to the estate of deceased, okay? Otherwise, you can go for what you call revocation of a simple grant. So protest is itself or is done or filed through an affidavit of protest. We have what we call an affidavit of protest when it comes to probate. So when a person files, when a disputant files this affidavit, unlike objections and revocations, where the court conducts, what we call separate hearings from those of confirmation of grant, for protest, it happens simultaneously, with the hearing for confirmation of grant, such that when one has protested, the court will entertain the protest, in the case in the course of confirmation hearings. So what you need to understand is that protest is, usually to the proposed mode of distribution. Okay, it doesn't have anything to do per se with the substance of the will. but of the mode of distribution of the deceased net intestate. Okay. What else? I think if I were perhaps to highlight and protest, I'll do so by what exactly I've said, but please check Rule 40, specifically Rule 40, Sub-Rule 6 of the P&A rules. It will be more clearer. So, the other question was on what? Was on, is it the documents that accompany planes? Or what exactly did you ask?
What I asked was, there's a person who was asked for documents that accompany a plaint, but then
Yes.
the follow-up question was, in what instances instances when you don't file a witness statement? That was the follow-up question.
Thank you. Okay, thank you. Well, this is always a common question in oral exams. So, what documents do accompany plaint? You have a witness statement, and I think that's where the follow-up question came from. If a plaint has a witness statement, then tell me which pleadings do not require witness statement. Simple. And then there's what else? There's the list of documents that you need to rely upon. So perhaps the mistake that litigants do, you only rely on the documents that you've mentioned on that particular list of documents. So in practice, it is advisable that you could say, you could add, you have 4 documents, and then the 5th, you say any other document to the leave of court. That one you're actually safe, because if you'd forgotten a given document that was quite, vital to your case, that with the leave of court, the court will grant you see, that breather. So it will be so convenient, and like in a situation whereby you didn't even include that specific provision, like any other document with the leave of court. So the court will only limit you to the documents that you've actually provided or listed on your list of documents, because it will be injurious to the other party, to the to the opposing, party, whereby, you want to include more, documents that you didn't list, or your list of documents, or that you listed but you didn't say with the leave of court. Okay, so for purposes of fairness, transparency, accountability, injustice, and all those overriding objectives in the Civil Procedure Act, then that will be quite fatal to the opposing party. Yeah, so I've talked about list of documents, I've talked about list of witnesses. There's also you are sort of verifying, we call them, there's a term, averments. Yeah, averments. Okay, so averments are on the plate. Okay, and then verifying affidavit on the same, because you are only trying to authenticate exactly what you alleged on your averments. Okay, and then what else? Yeah, list of documents, verifying affidavit, list of witnesses, and now the plaint itself. I don't know if I've missed any other document. So now instances where you don't even require a witness statement. One, I think, which is quite important. I had to. I think I always keep on forgetting to remind myself, but one is the constitutional petition, okay? You don't require witnesses for a constitutional petition, because is it Article 20? I'm not certain, where it says that where your rights are actually, threatened or infringed, then you have the liberty to go to court. So yeah, constitutional petition is one of the pleadings that don't actually require a witness statement. The other one, which I'm not sure, like I have it in my mind here, but again, it's far from reach or remembrance. What is it? Oh my God. Why am I forgetting this? But it's I remind myself and then I'll get back hopefully. But what has always stuck on my mind is a constitutional petition that doesn't require a witness statement. I think the panelists were only, because since it's a follow-up question, no one answer could do. But remind me, perhaps, hopefully, after this, and then I'll get back via WhatsApp, hopefully. So the other question was it on objections? You asked me such a question?
I think you've covered objections. The other one is citations.
Perhaps just because I was much more focused on protest, just to brush through perhaps in 2 minutes or something. Objections themselves are found, I think, under section 68 and 69, subsection 1 of the LSA. So all grants, once applied for, must be advertised in the Kenya Gazette within a period of 30 days. So where no objections are received by the courts, okay, the letters of grants are issued. Where objection, where objections are received by the court, one, that objection has to be filed in triplicate. You have to remember that, not duplicate, but in triplicate. It's quite vital. So objection has to be filed in triplicate to the court. Okay. The second procedure, objection entered into a register by the register rule. And I think when this objection is entered into a register by the registrar, I think under Rule 17, sub-rule 12 of the P&A, and then registrar will then send a notification in form P&A 61 to the applicant. So the applicant in this particular scenario is the proposed administrator of the deceased net intestate estate, okay? And then, or alternatively, instead of sending that particular, notification, the registrar may send actually a copy of the objection by post to the applicant's address, okay? And then the registrar again sends a notification in form P&A 67. Remember, the first notification was in form P&A 61. So here, for the second step, the registrar will send, a notification in form P&A 67 to the objector, requiring the objector to actually file an answer to the petition by way of what we call a cross-application pleading under Rule 17, sub-rule 5 of the P&A. So if no objection has been filed, the answer and cross petition, the court may proceed as if no objections has been raised. You can see section 69, subsection 1, and then section 70 and section 71 of the Law of Succession Act. And then the third step, now we have what we call directions. So the registrar refers now the matter to court for directions once all the requisite paper has been filed. And then the next procedure, the judge will give direction as to who is actually entitled to start during the trial. Is it the defendant? Is it the objector or the applicant? And a common question in the oral exams, define what do we mean by the plaintiff's right to start? A very common question, okay? So the next step, which is actually step 5, the registrar will notify, both parties, which is the petitioner and the objector, of the time and place set, for hearing of the petition, and then also answer and cross applications as well. So the dispute between these two would then be determined, I think, under section 69, subsection 2 of the LSA. Okay, but what you have to note, which is quite, weighty, is that objections may be withdrawn by way of a notice to withdraw. And this is done through Form P&A 66, and you can find this under Rule 17, Sub-Rule 7 of the P&A rules. Okay, and then you have to note that any objector, the person who is against that particular application for objection, any objector may actually mend his objections, by lodging an amended answer and cross application. Okay, so a copy is actually required to be served on the petitioner if this is so done. Okay. Yeah. So the next stage will now move on to confirmation of a grant once all those matters have been settled. Yeah, I think I'm done with objections. So you mentioned things to citation, did you?
Yes.
All right. For citations, you can check rules 21, 22, and 23 of the P&A. So what normally happens, if the person entitled to apply for a grant fails to do so? That should be the first question. And I think this thing came in our by exams. It did, citations. So what happens now if the person entitled to apply for a grant fails to do so? A number of things may happen, but must know is that any applicant now may apply rather, but the procedure is by way of a citation, signed by the registrar and supported by an affidavit. So that's the meaning of citation. It only takes place where, the person entitled to apply for a grant fails to do so. Okay, so which forms will now be used during citation? Where there's a will, the form that you'll use is Form P&A 31. And then where there's actually no will, the form that you'll use is P&A 32. Okay, and where there are actually creditors in place, you'll use Form P&A 36. So remember those three instances. One, you have an instance or situation where there's a will, it's Form P&A 31. Second instance where there's no will, Form P&A 32. And the third instance where there are actually creditors because perhaps the deceased owed a number of people some money, perhaps based on the services they provided or perhaps on the goods they procured in what have you. So where there are creditors, you'll use Form P&A 36. So now what's the procedure for citation? So the first step, a service of citation done on the citer or the citor. I don't know why, law has this, citor, chargeo, whatever. But the first step is, our service of citation has to be done on the citor with a copy of the form duly sealed. Okay, so the method of service is as directed, by the registrar. Okay, but the second step, the person cited once, served, they are to actually enter appearance within 15 days. You understand that's a fundamental rule of the civil procedure. And then the third step, if no appearance has been entered, the applicant citor, the person who has actually petitioned the court for citation because the person who was responsible for administering the estate fails to do so. So that's the person called citor, just to be clear. So the third step now, if no appearance has been entered, the applicant citor may petition for grant. And then the fourth step, in the alternative now, in the alternative summons to be taken out or notices to such person cited to take out the grant or by other person. Okay, that's what we call perhaps alternative summons, where now summons to be taken out or even notices to such person cited to take out the grant or by other person. But what you have to note is that proof of service is required. You have to ensure as an applicant citor that you've served the other party, okay, for the purposes of the court's records. And then once application for citation is granted, the letters of administration is applied in the normal way. Okay, so there's also a purchaser. There's also the right by the public, trustee. The public trustee has prior rights over an estate of a creditor. Okay, so the creditor or the purchaser asks, consent of a public trustee to apply for letters. This is where an instance whereby now the purchaser is the citor. Okay, so now if consent is actually granted, the purchaser and creditor may prove the estate owes them money by attaching a sales agreement. Okay, so the purchaser or creditor, applies for grant of now letters by serving citations on all the beneficiaries, right? That's the instance where you have a purchaser being the applicant citor. The other one was just a normal way, perhaps could be a beneficiary or so. Yeah, so that's it. Done. So what you have to notice that all applications for grants must be accompanied with a death certificate. That's a must. Because the dead tell no tales. That's the only proof that they've perhaps transited into another life. Okay, so the consolidated practice rules states that a death certificate must accompany any application for probate or letters of administration. Even if you choose to forget all other documents, at least mention a death certificate. Okay. Yeah, so sometimes even the death certificate actually it applies where if the application is not made by an advocate. And if the death took place outside Kenya, pursuant to Section 118, which is normally for presumption of death, it actually must be made formally in the civil courts. So a death certificate is quite important. Yeah, I think I've now answered your questions conclusively and exhaustively.
Yes, thank you. Yes, very well answered. Thank you.
All right. What were the other questions?
We had someone who had asked the difference between regular and irregular judgment, I think. And then there's also interpleader and representative suits.
Okay. My network is a little bit unstable. I'm trying to. Okay. Okay. I think I'll start with the interpleader. Well, it's quite a whole topic, but I'll just do it in 2 minutes. Just a summary. I mean, things that will always be asked. Something come to by exams, but in a very tricky case scenario. So we were caught in between either going for the execution of decree by auctioneers, or you do an interpleader application. Yeah, quite CLA could be, I don't know, but that is some crazy question. But if you know exactly the elements of interpleader, then it was an easier question for you. Okay, so an interpleader proceeding. What you have to notice that there are three issues or elements you need to know. There has to be an existing property in disputes. So when they say main, property may take different forms. Property could be money, property could be, I don't know, something tangible, something intangible, could be just IP rights, could be shares. Yeah, so that's the first thing you need to know. The second thing, there's someone, should I call that person a neutral party? But there's someone who perhaps has no interest whatsoever in that particular property. His main aim or her main aim is to ensure that this matter has been dispensed with forthwith. And this now takes me to the last element, that this person will be okay with whichever way the court would, rule on the particular matter. Perhaps what he or she will be seeking as an interpleader is cost of the suit. That's all. So that's the summary. So now just trying to go into the in-depth analysis of the same. An interpleader proceeding is actually filed by a person holding property that is being adversely claimed by two or more people. So it is filed by an interpleader, for the court to determine who the actual lawful owner of the property is. So if the application is actually made by a defendant in a suit, the court may stay all further proceedings in the suit and proceed with the interpleader only. Could you please refer to Order 34, Rule 3 of the Civil Procedure Rules? And then what is important is that the application is made by way of OS, originating summons, unless made in a pending suit, which case it shall be by way of a chamber summons. And that's under sub-rule 1 of Order 34. Okay. So how does what's the nature of interpleader relief? So the basis of the right to interpleader relief is actually in the existence of a conflict between two or more persons claiming the same property or debt. So the object of an interpleader is to extricate an applicant from the embarrassment of being sued by more than one party in respect of the same subject matter and of putting the claimants in a position of using interpleader proceedings if they wish to actually enforce their claims. Okay, so the applicant must satisfy the court by way of affidavit, because an OS isn't a standalone document, a pleading. You have to support it by supporting affidavit. So the applicant must satisfy to the court by way of affidavit that, one, the things I said, the applicant is a neutral party with no claim or interest whatsoever in the subject matter other than cost or charges. And then two, there is no collusion between the applicant and either of the parties disputing that particular property. And then lastly, the claimant is willing and ready to deal with the subject matter in whatever manner the court so directs. And that's, I think, under Rule 2 of Order 34. So when it comes down to the application for interpleader, where an action has been commenced by, let's say one, or more claimants against the holder, the application is made by what we call an interlocutory application. Okay, so where an action, has not been commenced, the application is made by an OS supported by an affidavit, like I mentioned. So an interlocutory application is interlocutory, basically means it is within the pendency of the suit. Okay, so that one you'll have to use a chamber summons. Okay, so the summons now must be served on all the parties, that are claiming as against the property or money relief, if proceedings have already been issued. Okay, so if if proceedings, have not yet been issued, the court may do a number of things, and this includes inter alia. One, order that the issue be stated and tried with a direction as to who should be plaintiffs and defendants. The second thing, the court, may either, if all now the parties concerned or the facts are not, in dispute, summarily, determine any question of law and resolve the dispute. The court may as well, if a claimant fails to attend, order, that they be barred from prosecuting their claim against the applicant. So those are, the key things the court will do. So now when it comes to an application in support now, by affidavit, that is. So an application for interpleader relief should be supported by an affidavit, showing a number of things to include inter alia. One, that the applicant claims no beneficial interest in the property in dispute other than for charges or the cost. So an application is actually bad, where they have no claim to the subject matter of the claim, but, they have at least a financial stake in the result of the proceedings. So the second thing on that supporting affidavit, it has to show that the applicant does not collude with any claimant to the property. And then lastly, it has to show that the applicant is willing to deliver the property to the court or to dispose of it as the court so directs. Okay, so now if the claimant appears in a pursuance of summons, the court may order either the claimant be made a defendant in any suit commenced, or issues between claimants be stated in trial, where the court will direct who shall be the plaintiff or who shall be the defendant. And I think this is under Order 34, Rule 4. So Rule 5, Order 34 says the court may, with the consent of one or both parties and with regard to the value of the subject matter, where desirable, dispose of the merits of the claim and decide on the matter summarily on such terms as it may so be just and fair. So should the claimant now be served with summons to appear, just to substantiate, that the claim, and they do not appear as so directed, or they do not actually comply, with any order made after the appearance, the court may make an order declaring them and any other person claiming under them forever barred against the applicant. And this is under Rule 7. So this is, I would liken it to perhaps during a wedding, once the pastor there says or the priest says, anyone who is against this particular marriage, you should raise that claim right now or forever hold your peace. Okay, just the same thing. If these guys don't, appear here, they'll be forever barred from prosecuting any claim against the applicant. That's under Rule 7 of, Order 34. So no such order shall, however, be sustained against the government unless upon application by summons to be served, less than 7 days before the return day. Again, look at Rule 7. So the proceedings against the government. Okay, there's the Government Proceedings Act. You can please check it out at your convenience for more knowledge. So where the issue is a question of law and facts are actually not disputed, the court may decide, upon that question, without the trial of an issue. And that one is under Order 34, Rule 8. And Rule 9 says that the applicant now can be granted relief, even if the titles of the claimant have no common origin and may be adverse to or independent of each. So now you've done all this. Now there are what we call conditions for relief. So here, an applicant for an interpleader, must be sued, or actually, expects to be sued. And if he expects to be sued, then there must be a real foundation for the expectation. That is to mean a mere anticipation is insufficient. Okay, so the interpleader will be, refused if the applicant knows that the litigation between the claimant is about to be settled, or when the applicant knows that the allegation that an action is threatened is actually groundless, where there is a genuine doubt that whether any adverse claim existed. Okay, so such as perhaps insurance monies, which are normally paid under a fire insurance. Okay, you can check the case that Mungari is challenging. Is Watson? Is it Watson versus Pat Royal? Yeah, Watson. The Watson versus Pat Royal. Pat PART Royal ROYAL into bracket caterers. It was an All England Reports case way back in 1961 during our ancestors' time. So now the applicant must be in possession of the subject matter in dispute, as they must satisfy the court that they are willing to pay or even transfer the property into court. So if the applicant has disposed of the property, it is not sufficient for interpret the relief for the applicant to offer to pay over the value of the property to the person entitled. So there must be adverse claims to the same property or debt by claimants. And the other case that I think will support this is the case of Sargent versus Gautama. Sargent is Sargent. Gautama is Gautama in an old case of 1968. So the adverse claims need not have a common origin, and the claim must be actual and not merely anticipatory, like I've told you. Like a mere anticipation is not sufficient. So the claim must be actual and not merely anticipatory, but claim may be in the nature of lien or even right of possession. I don't know if you've covered lien in professional ethics, but you will. So liability only lies when the applicant is liable to only one of the claimants in respect of the subject matter, and an interpleader relief will be refused where it so appears on the face of it that the applicant is liable to both claimants. And you can check quite a 19th century case, an old one called Great Vex versus Shackle. Great Vex is great, and then Ovex, OVEX versus Shackle, SHACKLE, Shackle. So interpleader applications are generally refused when they can be adjudicated in other proceedings. Okay, so where the court feels like this matter could be decided upon in other proceedings, why would you have to bring it here? So yeah, so that's the basis where interpleader applications will generally be refused, where that particular matter itself can be adjudicated in other proceedings. Okay, so an application for interpleader relief should be made immediately before or after the commencement of the proceedings and should not be granted where claimant has already obtained judgment against the applicant for a debt, where the applicant has already paid over the money to a claimant entitled to the relief, or where the judgment has actually been given by consent. I don't know if you guys have learned about judgment by consent, but it's one of the types of judgments. So you can check the case of Plant versus Collins. Yeah, Plant is just Plant, Collins is just Collins, a name. So in sort of determining an application for interpleader proceedings, so here on hearing the application for interpleader relief, the court will usually grant an order releasing the applicant from the conflicting claims and order the payment of their cost and charges upon delivering custody of the property to the court. So the charges will actually include the applicants out-of-pocket expenses for their care and trouble with custody of the property. So perhaps they're seeking for storage costs and what have you. So the court must then now determine the issue between the disputants or the claimants. So the granting of now interpleader relief is actually discretionary. and cannot be claimed as a right. So you have to know that it is not a relief and a right, it is a discretionary in a relief. So it depends with the mood of the court. So the court will exercise, its powers when it is actually satisfied that in the circumstances of the case, it is only just, fair, and proper, that relief should be granted. You can check the case of ex parte Marcy Docks and Harbors. Ex parte Marcy is MERSEY, Docks is DOCKS, and Harbors HARBOURS. Again, a 19th century case under the Queen's Bench. Yes, I think with that I'm done with the interpreter. What is the other question?
The other question was on Ganeshi.
Ganeshi, wow, that again is another lengthy. All right. That's the last question. What? Is it the last question?
No. There was another person who I think is Karaoke who had asked about irregular and regular judgments.
Okay. Regular and irregular judgments. I think I will answer that after Ganeshi. That's the last question.
Yes, unless anyone else has a question.
Okay. Let me address the two, and we could perhaps wrap it up. Okay. So for Ganeshi proceedings, this is just sometimes, I think, was it the first week of your oral exam? Someone was asked about what is the order 23 proceedings, and I don't know if that person didn't have this at their fingertips, you're done. In other words, I mean, like the those proceedings, that you should have at the tip of your, fingers. Like you have you have like you have Ganeshi proceedings. You have interpleader. You see those things, you're asked what is an order 34 application. You know, the panel sometimes will just want to mess up with your mind. They know you are so used to interpreter, but they just ask you what is an order 34 application. The same way that person was asked what is an order 23 application. So if you don't know that garnishee proceedings fall under order 23, you are done for the day. Okay, so I think I'll proceed, and then I can see Noah is in, so I will let him perhaps answer the last two questions. So garnishee proceedings will basically fall under the attachment of debts. Okay, so attachment of debts is a process by means of which a decree holder is actually enabled to reach money due to the judgment debtor, which is in the hands of a third person. Okay, so to support a garnishee, there must be a debt due or accruing due. It is actually not sufficient to just show a contingent liability. You have to tell the court that here, there is a debt that is due. Okay, so it is a convenient method of executing against the judgment debtor, since the money is intercepted on its way to them before it comes within their possession. Okay, so I don't know why my network is a little bit unstable. Okay, the third person now, in whose hands the money is, not in whose hands the money is safe. The third person in whose hands the money is, which is actually sought to be attached, is called now the garnishee. The requisite proceeds are known as the garnishee proceedings, and the necessary order is called the garnishee order. So those are the three things. So those are the elements that make up a garnishee proceeding. You have the order itself, which is a garnishee order. You have that person in whose hands that money is either safe or not safe, is called a garnishee. And all these proceedings, is called the garnishee proceedings. Okay, so the garnishee order changes the obligation from paying a judgment debtor to paying the decree holder. Okay, so when do you institute garnishee? So here, the proceedings are actually instituted by a person who has obtained judgment or order for recovery of, payment of money by an assignee of judgment debt or by representatives, of a deceased decree holder. So who have been parties to the action, this particular action in which judgment or order in question has been given, made. Okay, so the test as to whether debt is attachable is whether it is owing by garnishee, and it is sort of the type of debt which the judgment debtor can enforce against. So such debt must be in existence at the date when the attachment becomes operative. Something that the law recognizes as a debt, and not just something that someone wakes up today and say this is a debt, or it is upon that threshold to be met, to be considered whether it is a debt or it's not a debt. So thus, when the existence of a debt depends upon the performance of a condition, there is actually no attachable debt until the condition has been duly performed. Okay, so where an existing debt is payable by future installments, you see, the garnishee order may be made to become operative as and when each installment becomes due. So now the money in hands, of a bank is actually attachable by garnishee, and the bank, has to show that whether the order nisi, there's order nisi and order absolute. So whether order nisi should not be made absolute by claiming a lien over the money in its possession. So now, until the garnishee admits his indebtedness, okay, to the judgment debtor, the garnishee order nisi cannot be meaningfully made absolute. So the condition upon which a garnishee order nisi will be made absolute is if that particular garnishee admits his indebtedness, okay, to the judgment debtor. So the existence and availability of funds belonging to a judgment debtor has to be conclusively established as a condition precedent to making the order absolute. Okay. although now a banker, has a general lien on all securities deposited with it by customers, unless maybe there is an express contract or circumstance which is actually inconsistent, with it. So that particular money is usually not the subject of a lien, as it is not capable of being earmarked. Okay, so the bankers now claim in such cases will probably be perhaps more of a set-off. I know you know what a set-off is. Okay, so what's the set-off? Different set-off and a counterclaim. Common question again. So now the procedure. What is the procedure under Order 23? So application is made by way of is made ex parte with the supporting affidavit, which must state a number of things. One, you have the name and address of the judgment debtor. You have the identity. You have to identify rather the judgment to be enforced. Giving the amount remaining unpaid rather. Sorry. You also have to state to the best of the information or belief of deponent. The garnishee is actually within the jurisdiction and is indebted to the JD. Sometimes the judgment debtor is called a JD. So don't panic when a panel, just mentions a JD. So state to the best of information or belief of deponent, the garnishee is within the jurisdiction and is actually indebted to the JD. And fourth, if the garnishee is a deposit taking institution, having more than one place of business, give the name and address of the branch at which the JD's account is believed to be held and the number of the account itself to avoid any errors. Then fifth, if all, perhaps or part of this information is not known to the deponent, the fact it is not, known would as well suffice. So the order upon application, may be made rather either or after the oral examination of the JD. Okay, so the order may be that such debts owing to JD be attached to answer the decree, including the cost of the garnishee proceedings. How much are they? So that order itself or a subsequent order can order the garnishee to appear before the court to show cause why he should not pay to the DH. DH is now the decree holder. Okay, so to the DH, the debt due from them to the JD. You can check Order 23, Rule 1, Sub-Rule 1. So 7 days before hearing of application, Order nisi now shall be served upon the garnishee at the JD. And this is under Rule 1, Sub-Rule 2. So Order nisi is under form, I think, number 16 of the Appendix A. So now, after doing all this, how do you proceed next? So you know the effect of the order. How is this order effected? So from the date of service on the garnishee, the order attaching any debt due or accruing due from the garnishee to the debtor, or so much as actually is sufficient to satisfy the claim of the DH against the debtor, including the cost, entered and ordered to perhaps show cause. Okay, so now by this I think we mean until now the service of Order nisi, there is no attachment of debt. So the service of Order nisi has to take place for the debt to be attached. So if the garnishee bona fide pays to the JD the amount of debt before service, the Order nisi is absolute, as there is no longer any debt to which it can actually attach. And where garnishee has paid the JD by check before the service of the Order nisi, the JD is under actually no obligation to stop that particular check. So if the check now is stopped or even disordered, the attachment will still operate. So the service of Order nisi creates what we call an equitable charge. I don't know if you've done analysis of charges in your classes, but there's what we call two types of charges. You have informal charge, which is always equitable charge, and then you have formal charge, which is another legal charge. So equitable charge is the informal charge. So when the panel plays around, you also play around. Okay, so the service of Order nisi now creates an equitable charge or an informal charge, and the garnishee cannot actually pay the debt to anybody, without in carrying the risk of having to pay it again. Okay, so when it comes to order absolute, the court has now discretion as to whether order should be made absolute. Okay, order needs it rather. So the court must have regard to the position of the other creditors so far as they are known by the court. And then the court must be satisfied, before it makes an order absolute that there is actually a debt in praesenti. A debt in praesenti is Latin. Praesenti means a debt in the present circumstance. Okay, so a garnishee order, will place the DH or the decree holder in the same position as an assignee of the JD, and will actually make him subject to the equities, which exist against the debtor. Okay, so the garnishee may also obtain execution of the money, may obtain execution rather if the money is not paid in accordance with the order absolute. Okay, so now any payment made by the garnishee in compliance with an order absolute, and any execution which is actually levied against them in pursuance of the order is deemed to be a valid discharge of the liability of the garnishee personally in that particular or respective proceedings. So the cost awarded against garnishee where the proceedings are improperly defunded are not to be counted in the discharge of the liability of the garnishee. So you have to distinguish between the two. So now the payment by the garnishee made under the order absolute will discharge any obligation to pay debt to debenture holders. Debenture is just a security. I don't know why you guys are in company law. So to pay debt to the debenture holders under a floating charge. Again, a floating charge in conversing, which crystallizes and then becomes a fixed charge. I don't know if you guys have learned that. So you have now the payment by the garnishee made under the order absolute will discharge any obligation to pay the debt to debenture holders and a floating charge that has not crystallized before payment. Because when it crystallizes, it becomes a fixed charge. Okay. So however now, where the decree holder has not yet received payment under a garnishee order absolute, a receiver appointed for the debenture holder will always obtain priority over the garnishee order. The same way when it comes to conveyancing, you have original charge and then you have subsequent charges. I think this question was part of our exams. So you have original, chargee, and then you have subsequent charges. How do you create a subsequent charge on an existing original charge? I'll leave that to you for your assignment. So now, where the court refuses to make the order absolute, it will actually direct order nisi to be discharged. Okay, so a garnishee order may be set aside where there's a mistake of fact. Okay. Yeah, with that, I think I'm done with garnishing. Yeah, so I'm done with the garnishee, and I think I'll leave the last two questions to Noah. Then we can drop it up. We can call it a night. So the last two questions were the difference between what? Regular judgment and irregular judgment. And then, yeah, that's it, right? Where or who? Who was I speaking to?
It was Kariuki who asked, and I think
Yes.
she asked difference between regular and irregular judgment.
All right, that's the last question, I suppose.
Yes, that's the last one.
Awesome. Noah, please take it up.
Okay. So good evening. The difference between regular and irregular judgments, that will take me back to consequences of non-appearance. But before I discuss this particular question, I would like to encourage you students. First of all, you are heading to term 3. As at now, you should know how to draft these civil litigation documents. So before I tackle that question, my advice to you is that come CLE exams, I pray that you should have known how to draft, the plaints, the application, the order 23 applications, the order 34 applications. Any scenario should be easy for you because as per now, CLE can test anything, and during our time, we really drafted. So my advice to you is that you need to polish up on the issue of drafting and how to do legal opinions. Those two areas, if you are good, then you are good to go, especially with regards to civil litigation, criminal litigation, and P&As and LWD, because during our time, LWD, everything was just pure drafting. So you need, as at now, the way my senior Lavins has discussed the issue of Ganishi, you need not only to know the theory part, but you need to familiarize with the application itself. How does it look like? And in fact, when you look at the application itself and know how to draft it, you'll have understood the whole order 23, how it works. So that's what I want to advise you before I tackle the issue of regular and irregular judgments. Now, when it comes to this distinction of the two, you'll have to understand the consequence of non-appearance. The distinction between the two is just a matter of procedure. So when it comes to regular obtained judgment, now let's assume a person has filed his plaint. You as the defendant, given that you know how, you understand how civil procedure works, you have been served with this plaint, and then within 14 days, you have filed your memorandum of appearance. However, maybe you have failed to file your defense within the required time, or within the next 14 days, you have failed to file your defense, or when you are served with the plaint, and then within the 14 days, you did not enter your appearance via a memorandum of appearance. So what happens in such a scenario where you have failed to enter appearance? It is a requirement that now the plaintiff has the power now to go to court and seek what we call a default judgment. Basically, you have defaulted to enter an appearance. So the plaintiff will now go for a default judgment. Now, this is done through what we call, it's not an application nor chamber summons. It's done through what we call a request for judgment. So the requirement is that the plaintiff now, when requesting for judgment, he must attach what we call an affidavit of service to show that indeed he properly served the defendant with the pleadings, but within the time required for him to respond, he has not yet responded. So as a matter of procedure, he must, when filing for the request for judgment, then he must attach what we call an affidavit of service. So the normal, I understand this is the term one thing, so I'll not go into it. So what happens once that request for judgment is filed or entered, then depending on whether it's a liquidated or an liquidated claim, that judgment that will be awarded will be enforceable. Now that is what we call a regular obtained judgment. You have followed the whole procedure, but then the defendant has not yet complied. You as the plaintiff has followed the requisite procedure, but the defendant has not yet complied. Now, when it comes to irregularly obtained judgment occurs in two scenarios. Occurs where now the issue of service. Now, when you realize that you are not properly served with the pleadings, and you know the rules of service, then that is what we call an irregularly obtained judgment. The plaintiff has obtained that particular judgment irregularly because, or the default judgment irregularly because he has not yet he did not properly serve you via the rules of service. So what you do when you realize that, you know, this plaintiff did not serve me properly, you do an application. What we call the application is called setting aside. It is normally done through a notice of motion. So what the court will do, if it realizes that the plaintiff obtained the judgment regularly, mostly they normally impose terms. For instance, they can tell defendant, okay, you have showed sufficient reason as to why this occurred. So just deposit some money into the court, you know, the accounts that the court may provide. So the court must be satisfied that indeed this plaintiff, you know, he did not serve me properly, or he served another person who, apart from my advocate. So before setting aside, you know, that particular default judgment, the court has to be satisfied that even though he was not properly served, there is some sort of merit in the defense to the case. So the defendant's case must have some merit. You know, sometimes you can be improperly, there might be improper service, but from your part, even you know that you cannot even win this case. So the court must really be convinced, even though there's that issue of improper service, which led to an irregularly obtained judgment, then in your part as the defendant, you must show that you have a case, there's merit on your side. So there's also a requirement that whenever there's a default judgment entered against you, then you must do it without unreasonable delay. So you must act promptly when you realize that you are being served with a default judgment. So I'll send you an application for setting aside a judgment. I don't want to waste a lot of time discussing this. There are certain things that you must show. One, that the plaintiff irregularly obtained the judgment either through, you know, improper service, or he did not serve you properly, or neither hukupata hiyo service. You are not even given the pleadings itself. You are only being served with the judgment. So I'll send you. That's basically, it's just a matter of procedure. The regularly and the irregularly obtained judgments. There's nothing much big difference between them. It's just a matter of procedure. So unless Ms. Immaculate, you want further clarification, that's it from me.
All right. Thank you. Thank you, Noah. And if any of you guys will need clarification, please just reach out to us, and the recordings will be uploaded and sent, you know, once the same has been effected. So it was nice engaging with you, and I still wish you the best, and give it your all. We are still available away from the teams, so you can still reach out to us on WhatsApp, and anything perhaps that we didn't, you know, touch on, we will do so. So yeah, I think the meeting will stand adjourned so that you can still use the WhatsApp to perhaps communicate. So yeah, thank you for joining, and all the best. And good night.
Thank you. Have a good night.